Thank you, Vanessa. Uh, my name's Megan Murray, and I'm so excited to be with you today. Thanks so much for joining us on this third webinar in our series on supporting survivors with intellectual disabilities. We're so grateful to Pam Malin from Disability Rights Wisconsin for partnering with us to present this series. If you missed the first two, I will put links to the recordings in the chat. Those are on our YouTube channel as well. Um, and uh, excuse me, please feel free to use the chat and ask questions whenever they come up for you. And then without any further ado, really, I'll pass things over to Pam.
Thank you. Thank you. Well, and thank you everybody for joining. This morning I woke up going, oh no, it's the day before a holiday. Will anybody show up? So I appreciate that you all showed up. And those of you who are watching the recording after the fact, thank you for showing up as well. So today we're going to cover understanding guardianship and consent. So a couple disclaimers. One, I am not an attorney, nor do I ever claim to be. I'm going to be speaking about guardianship in plain language, the way that I understand it, the way that I think advocates can understand it best. There's definitely some legal nuances that are not going to be shared in the same way from me as an advocate perspective as you would if you talk to an attorney. But this is giving you baseline information that maybe you can go further. And if you need more information about guardianship, I'll give you some resources for that, or you can always call our office as well. Um, so I also wanted to just point out that I'm going to refer back to a couple slides from other trainings that just this morning I decided to put back in because some of what we talk about is going to be related to the power and control that we had talked about earlier. And I just want to kind of tie it all together and help everybody kind of understand it better. And then lastly, I really want this to be a conversation where you get the information that you need or ask the questions that you need. And the slides are going to have a lot of writing on them. I'm not reading them word for word. That always bothers me when I go to a training and people just read the slides out loud because I could do that on my own time. So instead, I will just kind of refer to them and then you will have the rest to look at and refer to further and then ask questions if you have questions. I'm a storyteller, so some of the things I'm going to do is tell you stories that kind of intersect with information that I'm sharing, and we'll go from there. So, all right. So to get started, I'm Pam Malin from Disability Rights Wisconsin, the Victim Advocacy Program. I'm the Supervising Advocacy Specialist, and we have both attorneys and advocates that work in our Victim Advocacy Program. I'll share a little information at the end on how to get a hold of us and work collaboratively with us with victims of crime with disabilities. But please know that we are a resource to all of you as you do your work before or after you meet with the victim, whatever that looks like. And we want to be able to be helpful. So, okay, so moving on. So, what is a guardian of an adult? So, I don't know if all of you, and I'm sure some of you have this in your personal life. You have some people who you know, like who have guardians or that you've been around. So oftentimes we will talk about how if you're under 18, your parent is your guardian in most cases. I mean, there's always going to be some differences around, custody and things like that. But when an individual with a disability, specifically an intellectual disability, um, turns 18, sometimes people assume, parents assume, that because their child always needed help um, with their decision making, with finances, with personal care, whatever that is that they needed help with, that the guardian is going to inevitably be just shifted from parental guardianship of a child to parental guardianship of an adult with a disability. And that is not the case. And partly the reason I talk about that is there are some parents out there that will say that they are guardian, and they may not actually be what we call a legal guardian or a court-appointed guardian. So if somebody does claim to be a guardian, it is okay for you to ask if they've gone to court for legal guardianship, if they have paperwork for it. That shouldn't be something that anybody is offended by. In fact, I was a guardian years ago for a young woman when she turned 18, and I always carried guardianship paperwork with me because I wanted people to ask if I was her guardian, if I could prove it. Because I didn't want people to assume that she didn't have the ability to make any decisions. And we'll get into more of that as we talk about guardianship, but I just wanted to lay that foundation. So guardianship is a legal relationship created by a court when an individual is unable to make or communicate their own decisions regarding their personal welfare, their finances, or both. The court appoints a guardian to make certain decisions on behalf of the individual. And in this case, we're going to use the word ward because in our state, the ward is the person who has a guardian, and then the guardian is the person who has legal decision making given by the court for the ward. So in Wisconsin and probably most states, guardianship laws start from the belief that every adult has the right to make their own decisions. That is not always the way that it looks or that people treat it. Oftentimes, you'll see the bias around disability, and there's the assumption that because somebody has a disability, they have a guardian. If you attended any of the trainings that I had prior, you may have heard me tell a story about a friend of mine who has cerebral palsy, and she often ended up in the emergency room because of some medical conditions that came from her disability. And there were several times that she would show up at the ER and then sit in a room waiting for hours. And she would finally ask, like, what are you waiting for? Like, why aren't I getting the, attention that I need, or the doctor's coming in? And they would say to her, we're waiting for your people, for your guardian to come in. And she's like, I don't have a guardian. She has a master's degree in social work. Like, she can make decisions for her life. But the assumption was made because she had cerebral palsy and used a wheelchair, she had a guardian. So understanding that in Wisconsin, we want to lead with the belief that every person has the right to make their own decisions. And even if they have a guardian, it is still their life. And it is decisions along with this guardian or this decision maker. But it is the individual's life, the ward's life that we're talking about here. So Wisconsin splits guardianship of an adult into two categories. One is the guardianship of a person, and that has to do with health, safety, living, employment, and other situations around their life. And then guardianship of a state, which is an individual who needs a guardianship of the estate, is somebody who needs somebody to help them in the financial realm around paying bills, around handling their SSI or their other income, around any sort of financial matters that come into their life, not necessarily controlling it all, but helping them make safe decisions, that the things that need to be paid for their safety, for their living, are paid for first, and then they can have money to spend after that, which is what all of us should be doing, because that's how we live, right? We do our needs first and then our wants second. But we also have the choice, and we'll talk about this later, to sometimes make bad choices and live with the consequences of that. And guardianship doesn't always allow for that, but it should. So we'll talk a little bit more about that. I also want to make sure that you all know that in Wisconsin, unlike some states, we are not a next of kin state or a family consent state, which means that in most circumstances, if an individual is unable to make their own decisions, spouses and relatives don't automatically have the right to make those decisions for them. So that is where guardianship or supported decision making comes in. And again, we'll talk about that. And if there are any questions that come up, please Megan, jump in and ask if they're pertinent to what's going on the slide at that moment. Thank you. So for permanent guardianship, the guardian must find, or the court must find that an individual is incompetent. So incompetence is a word that we use in several different um, places in the world. So one is when it comes to guardianship. And what that means with guardianship is that the impairment or disability is probably permanent. The impairment causes the individual to be unable to make or communicate decisions with informed consent, and that the individual's physical or financial well-being is at risk. So incompetent is different when it comes to criminal court and somebody testifying on their own behalf if they're a victim. And that is a different procedure. And we're not going to talk about that today. But sometimes courts get that mixed up too, or prosecutors sometimes get confused as to if they're incompetent and need a guardian, then that means they're incompetent and unable to testify in court. And that is not the same thing. And there's a different process for figuring that out. But in most cases, the individual is fully capable of testifying on their own behalf as a witness in a court case or sexual assault or domestic violence. The court must also determine whether less restrictive options are available or acceptable to the individual, including power of attorney or supported decision making. So what you will hear a lot in the state of Wisconsin when it comes to individuals with disabilities who need care and who are providing or getting services and support provided to them, that they should live in the least restrictive environment. This is something that is throughout the whole country, these words are used. And what that means is if somebody can live, so let me back up. So when I first did the trainings, the first training, we talked a little bit about institutionalization. Now, people with disabilities were often put in institutions years ago. And sadly, that's kind of the vein that we're looking at right now, is that people are trying to make the argument that institutions are cheaper and better ways to um, house people with disabilities. The truth is it's not cheaper, and the absolute truth is it's not safer. So, we're in our country is kind of fighting that right now. But the wording least restrictive environment means if they could live in an environment either by themselves supported or with a roommate supported, then it's better than them living in a large facility with a lot of other people with disabilities. So the environment that will keep them safe within means and least restricted is always the best practice. An impairment is defined as a developmental disability, which we talked about earlier when we defined disabilities, serious and persistent mental illness, degenerative brain disorder, or other like capacities. And this is about their ability to make decisions. So what are the negative consequences of guardianship? So the challenge with guardianship is that there is this overreaching arm that says, if you have a guardian, then we'll make all the decisions for you, and then you will be safest because we're making all the decisions for you. And the overuse of power, which that should sound familiar to all of us who are working in SADV work, that would keep them safer, but it becomes this power thing that's happening, like power and control. So there's a powerful tendency on the part of the courts, the service system, and guardians to overuse the power to make decisions for other people. Understanding the reasons for this bias towards overprotection and its costs can also help to guard against it. So guardianship, when it is given by the courts, years ago, it was if a doctor and a court found you in need of a guardian and incompetent, you would lose all your rights and the guardian would make all decisions for you. about 20 years ago, don't quote me on that number, but it's right around there was a recodification in our laws in Wisconsin that changed it from taking away all rights to looking at what rights were taken away, what rights were shared with the guardian, which means the ward and the guardian make them together, which means there should be a process of finding a compromise or talking about why one person feels differently than the other. And then there's rights that the individual retains. Oftentimes, the rights retained are things like voting, the right to marry, um, the right to get a hunting license, things of that nature, the rights to drive. But sometimes people lose those, sometimes people share those, and sometimes people retain those and can do that on their own. The challenge is that oftentimes the individual with the disability does not understand what rights they've retained, what rights they've lost, and what rights they share. And most of the time, their guardian makes a statement of sorts that I'm your guardian, I know what's best for you, so, I'm going to help you decide what you need to do and what you don't need to do and what you can do and what you can't do. And that is overreaching their role. So it kind of goes back to that power thing. Not always out of malice, but certainly still not the right thing. Okay, so these are some other just words around making sure that the person retains their rights and power, um, and that there's some equity or there's some conversations around what they want. And if they lose their decision-making skills, then they also lose some freedoms, right? Which is the thing that most of us really want and honor and crave, to have the ability to make decisions as simple as which doctor do I want to go to? Um, do I want to go to, um, do I want to work at place A or place B? Sometimes guardians say, no, you're just working at place A, and the choice isn't there. So really looking at not denying the person's choices, but finding out what the opportunities are and then helping them make better choices with that. So again, these are the slides that I entered in from the last couple trainings I did, because I want us to think about guardianship and about power and control and how they may intersect. Now, I want to say this. Many and most guardians are not doing it to control people. They're doing it out of a good place, out of wanting to make sure the individual has some choice and that they're helping them see their choices and navigate through their world in a safe manner. But the truth is that our world is made of abuse of power. Everything we do, the more I do this work, the more I see everywhere: government, medical, work, community. It's all about people who have the power and who take away some of your control and some of your choices. So understanding that a guardian can do that in a way that looks to be helpful, but it may itself be abusive, and seeing what that looks like. Again, not all guardians are like this, but it's important for us to understand that some are. And if we just assume a guardian can do whatever it is they're doing, then we're not looking out for the best interest of the individual with the disability, or the ward in this case. So just revisiting, guardians can have intimidation. I am currently aware of a situation where a young woman wants a new guardian. Her mom has been very, very controlling, to the point that if she spends $3, her mom needs to know exactly where that $3 went and what she bought with it. And then she'll say things like, well, you bought a soda with it. That wasn't a good choice. You need to drink, water or milk. And so every single choice she's made in her life is scrutinized, and then it's put into a power conversation around, if you continue to do that, you won't get any money to spend. Or you better make good choices or I'm not going to let you go to place A or place B anymore. All of that is not okay and not part of guardianship, but the individual with the disability, the adult child in this case, the ward, knows that if they go against what mom says, and mom is the legal guardian through the courts, that life could get worse, not better. Does that sound familiar? Yeah, right? It's part of the power and control of DVSA. So understanding that oftentimes guardianship relationships can look like that. And the challenge is that this young woman tried to assert her voice, hadn't had a voice for years, tried to assert her voice, found out the right way to request a new guardian through the legal channels, requested one, went through court, and the judge, who I personally know is a great man who he and I have talked at length around disability, and he's really thoughtful about decisions he makes, really made an a biased decision for this individual and made her life, quite honestly, worse, in my opinion. Um, because he said, tell me one thing that your mom does that would be considered abusive. And as she explained, he said, well, that's not that bad. You know, your mom loves you. Is that gaslighting? Is that blaming? Is it minimizing? And then, although he didn't pat her on the head, but it felt very much dismissive, like, well, your mom's doing that to keep you safe. And so she didn't get a new guardian. And now, guess what happens? Mom has kind of been given permission to take even more power over her daughter, and her daughter is miserable, to the point that she's been hospitalized several times for self-harm. And she herself says that she does that because that's the only place her mom can't get a hold of her and be in her ear, but the system won't listen. So knowing that that's an extreme, but that is definitely something that could come out of guardianship, I think is important for us to see. Again, not all guardians are like this, but this is the power and control factor. And I just wanted to revisit this a little bit because it goes into the factors that increase the ability to be abused in some way, shape, or form. Not knowing their rights, learned compliance, deprivation of attention, affection, isolation, and lack of control over life's choices. Those are all things that guardians can misuse. So understanding that that makes somebody more vulnerable to abuse. And often when I talk to guardians, I really do talk about how your intention may be well um, meant, but it won't necessarily protect the individual that you're so desperately trying to protect and that you love and care about, right? Again, this isn't always done with malice in mind. Many times it's done, at least from their perspective, that they're being protective and supportive, but it really does set somebody up sometimes for abuse and vulnerability, and maybe even not reporting things to the guardian because they're for fear that if I say I have a boyfriend and the boyfriend, wants to treat me like an adult and you want to treat me like a child, I don't want to tell you this. And that becomes this tool that the perpetrator might use.
Pam, we have a couple questions in the
Yeah,
chat related
please.
to guardianship and finances. The questions are, how much does a guardian cost, or how much of a stipend does a guardian get?
Well, the answer is depends. Um, so there's different kinds of guardians. So a guardianship is always, like I said, through the legal system. A judge does that. If somebody is protectively placed. So adult protective services would get involved. Let's say somebody was in danger or was being abused by a parent or somebody who has some power in their life, and they now need to get a guardian that's protectively placed. The courts would then most likely get a corporate guardian or find a family member that is appropriate. But if there's no family member that's appropriate, and oftentimes when there's protective placement, that's usually why they're protectively placed, because somewhere in their family there's been some sort of abuse or control. Um, the corporate guardianship is a whole, it's a business. So there's corporate guardians around our whole state. If you Google Wisconsin corporate guardians, there's a whole list that'll come up. Some people are small mom and pop kind of things that have 5 people maybe that they are guardian over. Some have 175. Corporate guardians get paid a monthly fee. They set it up themselves. I've heard anywhere from $40 a month to $55 a month. So it really depends on their company. And it also depends on the individual's income and what that looks like. If they're protectively placed and they don't have any money, Adult Protective Services or the county sometimes will pay for that guardian. So that's corporate guardianship. Most of the time, it is a family, friend, or volunteer guardian. Those guardians are not paid. They are often they are offered a stipend. When I was a guardian, I could each year, as I did my request or gave my financial kind of statement, I could request then a yearly stipend. It was very small. To me, that wasn't what I was doing it for. So to me, that wasn't really important, but it's probably what most people pay in a year you get, or in a month you get for the year. It's pretty small. And some just don't get anything. If it's a parent, it's likely they don't get paid unless they then are a care provider, and that's a whole different system. That's through Family Care or Iris. So it really does depend. Many counties have volunteer guardians. So they're people that are matched up with somebody who needs a guardian. That's what I was when I was a guardian. Um, but I went into the guardianship that I did knowing this young woman was turning 18. Her parents were, in my opinion, quite controlling, and I heard them fighting. They were divorced. They were fighting about who would get her um, under guardianship and get access to her money, which to me, that was very wrong. She turned 18. She's now 40. So it was a while ago. Um, but when I became her guardian, she and I sat down and I said, if I do my job right in the next 5 years, you will get your guardianship back. And that is what happened. The courts weren't very happy because they want to say, did we do our job right? It should be permanent, right? Earlier, I had said that it should have some permanence. She just didn't get the resources and the skills that she needed in her home. And she now is thriving, but I'm still like one of those people who supports her making decisions. So um, I guess that's a long-winded way to say it depends. But oftentimes, especially when there's a corporate guardian, there is money that is paid monthly.
And we have another question.
Yeah.
If a ward gets married, does their spouse automatically become their guardian?
So that is, first of all, that's a right that they could retain, they could share, or they could lose. So it depends what their guardianship paperwork says as to whether or not they can even get married, for one. For two, we have this kind of crazy system that if you get married and have a disability, you lose a lot of your benefits. So many people with disabilities have to make some decisions that you and I don't have to make around if I lose my health care or my SSI or it gets diminished greatly. do I even want to get married? What does that look like? I know several couples with a disability who have gotten married, as in taking each other's names, and had a commitment ceremony, but not legally got married because of the benefit loss that they couldn't afford to do for their health. And then sometimes the spouse could apply for guardianship, and sometimes they don't. Again, that depends on the individual and whether or not they need it. I know some people who have guardians who are married and it works out just fine, and then others who their spouse have become the guardian. Again, that could be a power and control issue as well, right? So, there are no easy yes or no questions here, I guess is the best way for me to say it. Anything else on that?
We have one more. Could a family member pop up and petition the courts to become guardian of someone who already has a corporate guardian? Or once someone has a
Um,
corporate guardian, is that final and it can never be changed?
oh no, so guardianship can be changed. The young woman that I told you about, she filed paperwork with the court to get a different guardian. She filed it under guardianship abuse, and the courts didn't find the behavior of the parents to be abusive. So she didn't get a different guardian. She had wanted a different one. There's also one that you can award, can just say, I want a different guardian, period. That's what she's going to try to do next, I assume. But that still has to go through the court process and has to be decided. And then, like I said, with the individual I was guardian for, we appealed to the courts to get guardianship dropped altogether. So it is not a forever kind of thing, although I think many people get one and it just stays in place. But there are some rights around it that we'll talk about next, like what are the rights and responsibilities of guardians and the rights of wards. But it is not a easy thing to change is what I want to make sure everybody knows. It's not just like, oh, I think I'll change my guardian tomorrow. That is not the way it works. A guardian ad litem similar to children in a divorce kind of situation happens. And even though these are adults, this is doing what's in the best interest of the ward. And so that's why there's a GAL that's put into the system for them. And then they can get their own guardian if they are own attorney if they want as well. So it becomes a very messy process. All right, so I just wanted to put up a few things. These, fear of reporting abuse. I think that young woman I talked about, like all of these things are absolutely what are happening to her. She has a fear of retribution that is happening, retaliation, not being believed. The court didn't believe her in the same sense that she needed. So it really is a barrier to getting what she needs and being heard. And it's because she has a disability that bias is there. All right, so guardian and ward rights and responsibilities. I'm not going to read all of these because it's a lot of talking and we don't have a lot of time, but there's the website that's referenced on here, GWAAR.org. They have it's an aging resource page, but it also has guardianship information, including what do guardianship paperworks look like, how do you understand it, what the ward's rights are, what the guardian's responsibilities are. So I sometimes will sit down with an individual who has an issue with their guardian and talk through these rights just to see that they know what their rights are. And then also talk through the next slide, which is the responsibilities of a guardian so that people are aware. I'll even sometimes send this to a guardian and say, I just want to remind you, this is what it says in our law around what your responsibilities are. And it talks about how, if you look at the second to last bullet point, make diligent efforts to identify and honor the ward's preferences. And if I had to say, what is the biggest thing that I see happening with guardians, it's usually that it's really more about the preferences of the guardian and not of the ward. And it's important that guardians understand that just because they don't want something to happen or don't like something doesn't mean that transfers to the ward and that they make that same decision for them. This should be a conversation or somehow finding out what the ward prefers and then making the decision. And then there's some more when exercising powers as guardian of the person, you shall. So there's some pretty strong language around um, what needs to be done within this as well. Um, and then guardian of person supersede any previously issued letters of guardianship of person. So if there were other paperwork, once it goes to court, that's the one that trumps it, or the most recent court. And it terminates when the ward dies. So sometimes I've had guardians say, I can't even like do anything. The day the ward dies, I now can't even like put the money where they wanted the money to go. There's things like that. So there's some agencies that help with trusts and burial trusts and things like that, which guardians often are very familiar with. So the thing that I think pertains to our work the most is that we will often hear either in court or from guardians that they have the right to tell if somebody has a guardian, they don't have the right to have consensual sex. And that is not true. That's not written anywhere in the paperwork. It says that guardians do not have the right to tell their ward that they can't be in a relationship or have consensual sex unless, and here's what the wording says, the guardian can prove that the other person is dangerous or unsafe for their ward to associate with. So if we know the person has something on CCAP, then we're pretty certain that they've committed a crime, right? Because that would be on CCAP. So that would be something that they could say, no, this isn't a safe person. Let's talk about why seeing this person is not okay. But just because I don't like that person, that is not a good enough answer for a guardian to say, I forbid you to be around that person. One of the things that it says in guardianship is that you have the freedom to associate, the ward does, with anybody that they want to, and that can't be taken away. And here's the wording again, unless the guardian can prove that the person is dangerous or unsafe to the ward. So understanding that, so sometimes we have guardians say, oh, my ward was sexually assaulted. And really what we find out if we take a little time is that this might have been a consensual relationship, but the guardian is saying it can't be consensual because they have a guardian. And that just isn't true. So sometimes finessing that and figuring that out with the ward is a little challenging. I've been in plenty of SANE exams where that's really been kind of the conversation I've had to have to figure out if the individual understood that what consent meant and that this was somebody that they consented to having sex with, or whether or not that was manipulated, right? And who then gets to decide that? I don't know. I mean, that's the great question. So I just wanted to share this. This is how I talk about consent with individuals with disabilities when I'm working on the curriculum. And the next training we have in August is introducing everybody to the curriculum and the online training for the curriculum. So we'll talk about this more. But I used to always talk about consent, and I didn't talk about what you need to do to get consent. So it was through that experience that I made not only what is consent, but then how do you give it or get it? You ask, you wait for the answer, and then you respect the answer. And then it has to go both ways. So we'll talk more about that when we talk about the curriculum. So here's some important questions that may help like interdisciplinary teams or MDTs to determine whether a referral should be made to seek a formal assessment of an individual's capacity to consent to sexual activity. So there are some resources that look at consent and what that looks like. The challenge is that does the person know what consent is? Who are we to say if they understood it or not? So it isn't this legally binding black and white assessment that we can say, oh, that person couldn't consent. I had a case years ago where um, somebody, a neighbor came over to the house to try to borrow something. The woman let him in, and then he proceeded to sexually assault her and then left and stole her wedding ring in the process. And the prosecutor was going to charge second-degree sexual assault, which, if anybody knows, that's the inability to give consent due to mental capacity. And we were like way far down the road in the process of getting close to trial. And he said, I don't think I can do this. And I said, why? And he said, because she has a husband and she consents to sex with him. And I said, but that doesn't mean she consented with the person who assaulted her, which is the truth. But the challenge is that inability to give consent due to capacity usually means more than in that moment. So that's why I have frowned upon using that as the charging tool. And there's other better ways to charge cases for people with disability that puts the onus on the abuser and their activity as opposed to the consent of the victim. This is just the wording of what consent is in our laws in Wisconsin. And this is the charging that I talked about. So I'm not going to get into all of that, but if there's ever a case that comes through your county or that is a conversation with prosecutors or law enforcement that they want to know more about this, please reach out to the Victim Advocacy Program and we can talk more about this. The one that I've had the most luck with is the third-degree sexual assault. And then you add a hate crime enhancer, especially if it's a caregiver or a guardian or somebody who is very aware of the individual's disability, making sure then that they understand that the person who took advantage of them or assaulted them was aware of the disability and targeted them because of the disability, which then makes it a hate crime, which then makes it a felony, which is much easier to prove than inability to give consent due to capacity. Okay, so one thing I want to hit and make sure all of you either take time to look up more or to talk about more is dignity of risk. So if we were in a room right now, I'd say, please raise your hand how many people have made a mistake in their life. So I'm going to just make assumptions and say everybody has their hands up, right? They made a bad decision, made a mistake in their life. We've all done that, right? So if I also then asked everybody in the room, how many of you learned more from the mistakes than the successes, I think we would have a lot of hands up as well. So knowing that sometimes the biggest learning opportunity is when a mistake was made, that is a right that we all have is to make mistakes, learn from those mistakes, and then use them going forward. And that is called dignity of risk. So people with disabilities often don't get the opportunity to take risks because they have guardians around them that are kind of putting what I call bubble wrap around them to say, no, 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 we're not going to let them do anything that's scary or dangerous. Therefore, they will always be safe. So I often say that in that bubble wrap often is where the perpetrators live because they're people that are known to that individual. And if we don't give opportunity to learn and grow around healthy relationships, and that's one of the reasons why we made the curriculum and found the grant to do that, then when somebody does take advantage of them or use their disability against them, they don't always know what's going on and it becomes abuse. So, dignity of risk is making informed choices and being able to take reasonable risk and learn and grow from those risks just to have a better quality of life. And I think we can all safely say that we've all experienced that. That's been part of our lives and probably the place where we've grown the most. So just quickly, supported decision making is an alternative to guardianship. There's a link here on the bottom for you to look at, and it's a booklet that talks about how to have somebody in your life that will help you make decisions, but is not your legally appointed guardian. So remember the woman I said I was guardian for, and we went back to court and got her guardianship back. Supported decision making did not exist when we did that, but it is a great example of what supported decision making is. So there is a form that somebody can fill out to say, when I'm in a decision for my health, a decision for my finances, a decision for whatever big decisions in life. These are the people that I want in the room with me. And that can be put in writing, and that's a legal document that can be given to the doctors, can be given to the bank. And so the individual that I was guardian for, I am kind of her person. And she had back surgery a couple of years ago. She wanted me to come to the appointments with her. She didn't have me make the decisions because that wasn't my place, but I helped her understand what the choices were and then the consequences of the choices. And then she made the decision. She also needed to buy a new car. So when I became her guardian, her mom had the doctor write paperwork that she could never drive. When I became her guardian, I said, so do you want to drive? Yes. What do you need to do to learn to drive? So she set out all of the kind of milestones she needed. And eventually she got her license and she drives. I don't know if she's the safest driver, but neither is my husband. So I don't think that has anything to do with competency. That has to do with just, some people are better drivers than others. Don't tell my husband I said that, although he's probably pretty aware. Anyways, but she needed to buy a new car. So she called me and said, here are the ones I'm looking at. This is why I think I like this one better. And I would ask her questions just to get her to think about it. And then she made a choice, and that choice was solely hers. And it wasn't my place in any way to say she made a bad choice or a good choice. She made the choice that she wanted. So that's what supported decision making does, but now it's in more of a formal manner. And if you look at the booklet that the link is for, that'll give you more information. All right. And then just wanted to give a few glossary of words. So those are for all of you to look at. And then I added this one slide. I had somebody ask me some questions about this, and I called Ian and said, okay, Ian, what should I put for this and what should I do? Because I'm not an attorney. And after a conversation, he said, I think maybe you can explain it better than I can. So this is my explanation of this. So oftentimes people will say, who has to sign the legal paperwork or the release of information for the individual, the victim that I'm working with, if they have a disability and they have a guardian. So I would say if somebody says they have a guardian, you have the right to ask for guardianship paperwork, and they shouldn't get mad at you for that. That is just making sure that you're not making an assumption that they are a guardian when really they're just a parent. I don't mean just a parent, but as an adult, that they're kind of using more power than they should. I don't always ask for the paperwork, but I will say, did you go to court and did a judge appoint you as guardian? Because that will tell me if it's no, I just assumed I was guardian, or if I went to court for it. Sometimes I ask for paperwork. Depends on the situation. So who can sign the release of information? This is a little gray. I mean, it's clear that guardians should be the person signing. But the truth is, in the work that we do, if I'm going to talk to somebody's, well, if I'm going to talk to the law enforcement or prosecutor about this individual, even if they have a guardian, they should know that I'm going to talk to them and give me permission to talk to them. So the best practice is that the guardian signs it and the ward signs it as well, so that they understand what it is. Because remember, we talked about this is their life, these are their choices, and the guardian is there to help them make those decisions, and certainly legally has the right to sign things. But understanding that our client, our victim, our person we're working with is the person who should know why we're doing this and should sign so that we know that they understand why we're doing it. So that's one thing. If the guardian is not supportive of them working with um, the victim advocacy program or the sexual assault program or the domestic violence program, the individual can still come to us for assistance. And depending on what they're needing from us, we can meet with them. But then you might have to consult with your agency policy to find out how far you can go. It used to be in an old agency I worked at, I think they had a rule that I could talk to them up until the time that I referred them to therapy, and then I couldn't talk to them anymore without the guardianship permission. It just depends on your agency. The thing that you need to know is that if the perpetrator is the guardian, then that changes everything. So, or if the guardian supports the offender, the perpetrator. So I had a case a couple years ago where the guardian was married to the offender, which was her father. And the guardian refused to let us have access to the ward, but the ward wanted us to be involved. So, with the ward's permission, we met with the individual in a place that we didn't need their permission. But we had to look at our agency policies and see what worked and what was the right way for that. So I'd ask all of you to just kind of have that conversation before you get to that point. And then when it comes to SANE exams, consenting, the guardian has to consent for any medical procedures. Just understanding that a SANE exam is not medically necessary. A SANE exam is for forensic evidence collection. So there is a difference, again, knowing the policy of your agency or your program and knowing the policy of the SANE program that you're working in. We have a couple times in my experience, gone ahead with the SANE exam because the individual wanted it, but not the guardian. And sometimes the guardian wanted it and the individual didn't, and we didn't do the SANE exam because the individual has the right to own their own body and decide what's going to happen with that. But that's tricky. So I'm asking you to just kind of look at your policies and figure that out. The number one thing, though, from this slide to remember is that if the victim can sign in addition to their guardian so that they understand what you're asking for or releases for, that is best practice. All right, so the last couple slides I've put in, I'm going to quickly slide through, but I put in every one of the presentations, and that's how to reach out to our program, victim advocacy program at Disability Rights Wisconsin, and how to refer to us or work with us. We are a co-advocacy program. So we provide advocacy along with the local DVSA provider. So it's not duplication of services. It's just really enhancing the services and making sure the victim is getting what they need. And you can call our 800 number and ask for the victim advocacy program, or the individual can call the 800 number for a referral. So I'm going to open it up to a couple questions because I know that I'm, sorry, getting pretty close to my wrap up time.
Think we just had one question that we didn't get to that came through so far, which is asking about, I think that they're referring to guardianship when they say this. Is this the same as power of attorney?
No. Okay, thank you for asking that. So power of attorney is has to be put into play by a doctor. There's power of attorney for healthcare, and there's power of attorney for finances. And so that is something that can be all signed up and done legally, but it doesn't get put into practice until that individual has been deemed unable to act in their best interest for healthcare or finance. So that is kind of like an example would be for, my mom is 84. So if and when she becomes incapacitated, either because of an illness that she might get better from or something that she won't get better from, then the doctor or the powers that be would say, at this point, I would request, at this point, she can't make these decisions. They would make that decision, and then we would kind of kick in the power of attorney. But that is not something that follows somebody the whole while. It has to be put into play when it's legally necessary, not just forever. Any other questions? I know this was a lot of information and I like jammed a lot on the slides. If there's more that people want to know or specific things, please feel free to call me or call our program. I am privileged to have access to many great attorneys in our program that they can answer in more legal terms. Again, like I said, I'm plain language, I'm the advocacy perspective. Um, and there might be a few things I said that there's some tricky workarounds, but for the most part, it's really about making sure that the individual is their needs and their wants are at the forefront of what's going on. I just saw somebody ask about sharing the slides. And yes, I believe that those are sent out. I think they're accessible, Megan. Now I'm questioning myself,
I'll confirm that we got those
but I
sent out.
think so. I think so. Yeah. And then I
Um,
saw one other question come. What was that? Oh, do they have to live in the same state? I think I saw. Um, they do not have to live in the same state. That is not a requirement, but there is a kind of a best practice assumption that that the person would have a certain amount of contact or connection with the ward per year face to face. It is more of a best practice. It's not something that's being held to, I don't know. Like I know people who don't have as much face to face as they should, and they're still not, the guardianship isn't taken away. So, and then the next training is going to be talking about the curriculum. So anybody who signs up for that will get a copy sent to them. So that should be exciting.
yes, please join us for session 4 on August 13th, correct?
August something. I don't know. I don't have it in
August
front of
13th.
me.
I
Okay,
wrote it down right before this because I knew I
good.
would forget by the end of the meeting. So excited to have folks with us today. Thank you so much for joining us. Pam, do you mind if I share your email in the chat for folks
Oh, yeah,
if they want to
please
connect with
do.
you?
That's fine.
All
Yeah,
right,
please do.
great.
There's
Uh,
also there's also a YouTube channel, and I didn't put this in the resource thing, but I will make sure I put it on the next training that has Wisconsin Board for People with Developmental Disabilities has a YouTube channel called the Self-Determination Channel, and people with intellectual and developmental disabilities take every right that a ward has and talks about it for 7 to 8 minutes. So it's somebody with a disability talking about what your rights means. I've used that several times for individuals to like watch a YouTube video just to kind of know what their rights are. And I think it's a really nice resource to have. So
I love that. I can't wait to get my hands on that resource.
yeah. All right. Well, thank you, everybody. Enjoy your weekend. Be safe. Hopefully, it doesn't rain the whole weekend. Kind of feels like it's been raining a lot lately. So.
Yeah.